Yes, I'm Jay Wilkinson, and I've been a judge on the Federal Court of Appeals for the Fourth Circuit since 1984. President Reagan appointed me, and I think more importantly, I'm a father of 2 children, and just had my first grandchild not so long ago. Yeah, I went to the University of Virginia Law School, and I went to Yale to college and came back to Virginia. And I came back to Virginia to law school because I thought, in addition to going into law, I might want to run for office in Virginia politics. And so it was a good thing, I thought, to return to the South and to Virginia and to begin to set up a political career. And I ran for Congress when I was in law school, 25 years old. And I took a sabbatical from law school to pursue this political career and run for the House of Representatives. And I was a Republican at the time and was facing a 3-term Democratic incumbent. They had a very effective, my opponent had a very effective ad about me, which said, send Satterfield back to Congress and Wilkinson back to law school. So the voters took that to heart, and I said to a reporter the day after the election that I did indeed receive a mandate, and that was to return to my legal studies. So I did that, and then had the, after graduation from law school, an old family friend, Justice Lewis Powell, Jr., had been appointed to the Supreme Court. And he was kind enough, I'd interviewed with some other justices, but he, because of our connection, was kind enough to ask me to serve as his law clerk. And I was just thrilled and delighted to do that because of the profound regard I had for him. But frankly, it was a little bit scary because I was going right out of law school into this Supreme Court clerkship. Now, normally you have a year as an appellate court clerk, and some others have a year or 2 in private practice. And I took the bar one day and went to work for him the next. And so I had a steep learning curve. We worked very hard because this was his first year too. So in different ways, we were both starting off. But it was kind of fun to clerk for a Supreme Court justice the first year in their tenure, because they haven't come to rest on all these issues. And so instead of saying, well, I've done this I did this in such and such a case several years ago, they would the justice would ask the law clerks their opinion. We'd be thinking through things. He was a little bit surprised, I might say, that his major assistants were 20-somethings, as he'd been a managing partner at a major law firm, and he had people working for him who had decades of experience in the law, and all of a sudden, here we were with no practical experience, asking him what the mechanics of garnishment were, and he would just drop his jaw because of some of the things that we were asking. But it was an absolutely wonderful time. I could not have clerked for a finer man. Yeah, I mean, obviously the experience we have as a clerk remains with you through life, and I think having been a clerk, it's like if you're going to coach a football team, it's good to have played, and if you're going to deal with clerks, it's a good thing to have been a clerk yourself, and I think I understand a little bit what to expect of them, and it makes me more forgiving of some mistakes because I committed them egregiously myself. Makes me a little less forgiving of others because I know what Justice Powell expected of me. But it's invaluable experience in that sense. Well, we were doing what law clerks have always done, which is write certiorari memos, and we would do the first draft of an opinion, but I say that was the first draft because sometimes there were about 30 drafts. It was not unusual for him to put his imprint on it at every stage along the way, and he had this habit of putting in riders. We had an old dictaphone, and he would dictate a rider. And the term rider was supposed to mean he was going to ride on our efforts. Well, it actually supplanted them completely. And he would, sometimes I wondered why he wanted our first draft, because the opinion was so thoroughly his at the end of it all. So you pick up certain habits about approaching a case from clerking, and one of the habits that you try to pick up. I would never equal Justice Powell in this regard, but one of the things I tried to pick up from him was an essential modesty. And I would ask him, I would say, Justice Powell, why don't you ask more questions from the bench? And he would say, well, you only ask a question if you don't know the answer. And he was very modest about things. He didn't want to grab a lot of attention or to do this or that, but what he approached his task with this profound humility, which was that other colleagues had things to teach him, that he had things to learn from litigants, he had things to learn from his colleagues. And I've seen a person who recognized the limits of his own experience to such an extent that he knew that America was such a vast country with such different traditions and different cultures and the rest, and he was very sensitive to the fact that he'd only had a limited slice of experience in this very diverse country of ours, and so that gave him a certain modesty, I think, on the bench. And he would tell me, that sometimes the best knowledge is to know the limits of knowledge. So you have this enormous modesty in this very wise man. I mean, we would expect, given everything that he had done. He'd been in North Africa at the time of the Allied invasion in 1942. He'd worked with Ultra to try to break the German code. He'd been president of the American Bar Association. He had been on all sorts of blue ribbon commissions, and as I say, he was a managing partner of one of Virginia's most prominent firms. So you wonder, well, here's this person with all that experience, and he's so modest. And it made me believe that qualities of judicial restraint were very important in a judge. And much of that I got from him, just from his being humble when given his accomplishments. Most people would not be. He just taught by example, you know. He wasn't a didactic man, and he had the softest voice. He put his hand to his chin, and you had to listen real carefully sometimes to hear him. So I never heard him raise his voice or speak in anger to anyone. And a lot of the times you just watched what he did. I mean, he was a 24/7 person in terms of his work schedule. And you know, sometimes I would leave occasionally, take the Sunday off, and I'd come back Monday morning and look at the seat of my chair and find all kinds of things that he'd been working on Sunday. So you had to be very careful about taking Sunday off, because you were going to find out. And he wouldn't say, why did you take Sunday off, or that I've been working on Sunday. He would never say that. But you would find the work in the seat of your chair. It's mostly habits that he brought to all the cases. They're just things that amuse me. He said, well, I'm going to Florida to take a vacation, 1 week vacation. I said, well, enjoy yourself. I said, you know, you work so hard, Mr. Justice, you can afford to relax. Well, I got to Florida. The phone was ringing. The mail was coming back and forth. He would want to know what was going on. And it's not that he, you know, didn't relax. He did on several times, but he just had a wonderful work ethic. And people say, well, that's not good, but it was good for him because he really enjoyed it. I mean, I've never quite seen someone that took so much pleasure in his work. He had his recreational pursuits, and particularly with his family, because he was such a great family man and he took so much interest in his daughters. But he genuinely took as much pleasure in just working as almost anyone I know. Well, you know, I think when judges sit on the bench, this applies at all levels, we don't really think about ourselves as conservative or liberal. That's those are labels that people apply to us, and I understand why they do, because you have to use shorthand, but the interesting thing is, I don't think most judges conceive of themselves as conservative or liberal. We think of ourselves as judges first and foremost, and that the judicial calling is such an honorable calling. And when we get on the bench, you know, you're just so focused on that one case. You don't think, is this a conservative result, or is this a liberal result, or which way is the law as a whole moving? You're just thinking about those people before you, and how much the case means to them. And our mindset when we go on the bench is this case is a universe unto itself. We hear hundreds of cases, but we need to remember that it's that one case that means everything to those who bring it. And that really is the mindset of the judge. You want to do the best you can in terms of the litigants before you. It's like when you go to a doctor's office, you don't want the doctor thinking of the patient before you or the patient after you. You want him thinking about you. And you don't want him to think of necessarily about larger trends in medicine. You want him to think about, okay, what's your case? And so it is with the litigants, you know. And I really think we just lock into the case, and that the satisfaction we get when we drive home at the end of the day is when we've done our best for the people before us. And that's such a source of satisfaction in this calling. It's just one reason I think that when you're in public service, you have to really derive your satisfaction from helping other people. I think people in Congress and everything, I think they take genuine satisfaction in helping individual constituents with problems. The best of them do. And we take satisfaction in helping individual litigants. And that, you know, all the salary in the world wouldn't give you the satisfaction that you feel at the end of the day if you've really wrestled with something and given it your earnest best. Not that you've reached a perfect answer or one that everybody would agree with, but just that you've given it your best. You can put your head on your pillow quite nicely that way. It was an evolutionary thing. I went back to law school and I just began to realize I really like this. I went back to law school to teach. And I really like the satisfaction of just being in that classroom and being my own person. And I think one of the privileges of judging is that you really do get to express your own convictions as they relate to the law. And a lot of people have very, very important jobs, but they're accountable in a certain sense to clients or to bosses or to the electorate or one thing or another. And we're accountable, but it's to the law, and we get to express our own convictions about the law. And that was one of the things that I found in teaching. I got to go and stand up and say, this is what I believe. And there are a whole lot of professions that don't afford people the right to say, this is what I think. But teaching gave me that latitude. And I decided that that was very important to me, to be my own person. So I went and was editor of a newspaper for a number of years. And part of what appealed to me about that job was being able, I was the editorial page editor, and I could get up in the morning and think, what do I think? What do I believe? And then I could try to persuade people or set it down. The same way with teaching, that you can say what you believe. Well, now, judging is a little more constraining because you're bound by Supreme Court precedent and by the wording of statutes and by obviously the Constitution and by standards of review and a whole lot of different things. You're bound. You're not totally a free agent by any means. But at the core of judging is the sense of independence and the chance to express your own convictions. And that's the most priceless thing in the world, to be able to be able to do that. So I've tried to get jobs that would let me do that, where I didn't have to express somebody else's view, although I really respect people who do that. Different, they're different jobs, but it's this independence. I think the big break I got was the chance to go and work in the Civil Rights Division in the Department of Justice, and I was a Deputy Assistant Attorney General, and I went at the time to the Department of Justice because the reasons we all do is a great chance for public service to serve, and I felt like, as I had spent a lot of time in Republican politics before going on the bench, I said, probably the greatest experience for a Democrat would be to work in the first 100 days of the New Deal. And I said, I am thinking that the greatest experience for someone with a Republican background is to work for Ronald Reagan's administration. So I went up there, and I really admired President Reagan a great deal, and I believed in what in what he was trying to accomplish. And you can have, you can serve in an administration and have all those things, but it's just a matter of luck, in large sense, as to what opens up for you. There has to be a retirement on the bench, and there are inevitably a lot of other candidates who are probably equally as able as you are, but you happen to know the United States Senator maybe a little bit better than they do. But then, it's so much luck and happenstance. Which party is in power, and is there going to be an opening, and who are the senators, and who are the congressmen, and who do you know in the White House, and all that kind of thing. And so sometimes we get the idea that we're on the bench because we were somehow ordained to be on the bench, but nothing could be further from the truth. There's just a large element of good fortune, just plain old luck, that contributes to us being here. Yeah, well, President Reagan had I'm not sure whether this still obtains, but President Reagan had a wonderful habit of calling every single judge he appointed before he submitted their nomination. So we all got, this is Ronald Reagan on the phone, and you sort of stammered. But no, he was that way, and I dealt more with, during the appointment process, with the folks at the head in the White House counsel's office, and at the Department of Justice. And it was the White House counsel's office and the Department of Justice that would work to shepherd the appointment through. Before going on the bench, you need to realize that you have to leave all your former lives behind. It's a little bit like just entering a cloister, but you have to leave party politics completely behind. Can't have any involvement in that. You can't raise money for anything. You even have to be circumspect in your associations if people could potentially have litigation or do have litigation before you. You have to be careful. So it's a different life, and I've thought about it at a young age, do I want to leave all this behind and maybe, because there's still a lot of things I wanted to actively involve myself in and be influenced, and we're going to take on the role of a judge. You sort of have to wait for things to come to you, And but I said, no, this is something I really, really want to do for some of the reasons we've touched on, and I've had absolutely no regrets. This job I presently have is probably the only thing I would have given up law teaching for, because I love my students so much and have kept up with many of them through the years. But I find that my law clerks, fortunately, give me a chance to indulge my teaching instincts, and so I don't feel like I'm leaving that completely behind. But I do miss the classroom a little bit. But this is, in my view, one of the best jobs in the world, because of it's intellectually fascinating and challenging, and you have a new question every day. The law produces infinite novelty, but apart from just the fascination I have with trying to unravel a very complicated legal problem, the main thing is it's a chance to respect people and to try to serve this a great country of ours and the wonderful values represented by the federal judiciary, and to make the law really, to have it become a source of stability in our national life, and to strike a proper balance between order and liberty, and being involved in those kinds of questions and feeling that you're playing a role in them, that's a big deal for me. Yeah, well, I thought at the time it was rocky, because we had there were filibusters and cloture votes, and there were numerous hearings, and I didn't think of myself as terribly controversial, but I understand why, because they were going to give a lifetime appointment to somebody in their 30s. I would have looked pretty closely at that too. So I respect them for doing that. It's just, I think that, serving in the Justice Department under President Reagan, there were some people that agreed with what he was doing, and there were some people that didn't agree, and they were going to take a confirmation proceeding and make clear what their disagreements were. And then there were other folks that thought, well, I should have had a much longer experience and much more professional experience, and particularly in private practice. Those were legitimate concerns. I mean, I could understand them. But the point is, if your age, your chronological age begins with the digit 3, and you're going to be on the bench for 35, 40 years or more, you should be looked at. It's not going to be as smooth sailing as it is for someone who's 60, and and facing confirmation. That's just the facts. And so there was a good bit of debate. It was constructive, and I really, as I say, you leave politics completely behind when you go on the bench, but you also have a feeling of gratitude for people like certainly President Reagan and Senate Majority Leader Howard Baker and the Senate Judiciary Chairman Strom Thurmond and my home state senators of Paul Tribble and John Warner. You appreciate what they did for you. It's and the way you show that respect is just by doing a good job, by being independent, by being dedicated, by giving every case the best you can. I think that's what they would want, was that you just go do what you think is correct under the law and just do a good job. Well, your approach is, you're probably better off saying less rather than more. You can only get yourself in trouble by going on at too great length. And so when I was at the committee hearings and things, I tried not to ramble on because I try to be responsive, but I think anybody who's up for Senate confirmation should realize that it's really the senator's day, and it's their forum, and they have a perfect right to use their time as they see fit. And one of the things they're going to do is voice their concerns over issues of importance to their constituents. So I just told myself, never interrupt, keep my answers short, and when the senators talk, to be respectful of what they're saying, no matter what point of view they were expressing. You can't roll your eyes or just go like that. You've got to be genuinely respectful of what they say, just as I would expect litigants to be genuinely respectful of what those on the bench says. We don't want a lot of adverse body language, and that's what I tried to avoid. Well, it's a job where you have to enjoy your own company, and you spend a great deal of time just reading briefs. But there are opportunities of bar meetings and symposia and everything to be sociable. It's not as monastic a life as some people think. You just have to sort of be careful about where you show up in a way that doesn't appear to commit you on a case, or that doesn't appear to anyone to be partisan. But basically, I think those in Congress use their ears a great deal to receive information. They're listeners in a big way at committee hearings and to their constituents and in floor debates, but their ears are very important to them. And I don't want to oversimplify the point, but judges, if you're a judge, your eyes are very important to you. You are reading all the time. You're just looking at one brief after another, reading one opinion after another, or reading one memo after another. I've hardly seen so many jobs that just involve more just reading. Doesn't mean, you know, an oral argument, you listen and you listen to your colleagues and everything, but we use our eyes as much as congressmen use their ears, and that's part of separation of powers. And maybe it's good that different organs of American government receive information in different kinds of ways. Of course, we listen and others read, but I'm just saying what I think a little bit of the emphasis is. Well, the main thing is it never stops. It's like waves beating on the beach. I mean, litigation never takes a holiday. And I mean, you know, there are periods where there are more cases awaiting resolution, and then there will be less. But you just never feel completely caught up. You don't ever. So maybe people in other businesses don't feel that way either. But you never. I can't remember ever saying to myself, "Well, here, I've done everything that needs doing." That doesn't happen. There's just always a checklist for tomorrow, and you don't. You never complete all the assigned tasks. There's always something else that you should do. You know, that's our docket is so varied, and sometimes I think we're among the last generalists. Alexander Pope, I guess, said that a little knowledge is a dangerous thing, but there's no way of avoiding the fact that we have to know a little about a lot of things. It's sort of daunting in a way because many of the topics are so specialized, but there's nothing that we don't consider, really. I mean, law is intimately connected with life, and if there's a problem out there in life, it's going to find its way into a lawsuit, one way or another. There's no issue there that isn't going to eventually come in some form before the courts. That's not to say we try to wave a magic wand and resolve it for all of society. But we hear a large number of criminal cases. The more serious crimes tend to come into federal court. We hear a lot of labor cases. We hear a lot of major commercial contract cases. We hear occasional admiralty case. We hear a good many bankruptcy cases. We hear all kinds of civil rights cases under many, many different civil rights statutes. We hear lots of tax cases involving very complex provisions of the Internal Revenue Code. We hear cases involving pension rights under the statute that many people probably haven't heard of. It's called ERISA. We just, I know if there's going to be an event of the shock and magnitude of 9/11, then that's going to produce some litigation. And if you have something on the that comes up, such as the tragic affliction of AIDS, that's going to result in all kinds of new problems in litigation. And if you have the rapid expansion of technology on the internet, then you're going to have a whole set of protocols and rules to deal with. in terms of that. So we have jurisdictional rules, but between federal question jurisdiction and diversity jurisdiction, we're going to hear most anything. Well, you try to read on a need-to-know basis. You have to realize that you're not going to be able to understand or know everything. And if we're not specialists in one little thing or another, we are specialists in law, and it's sort of that toolkit that we carry into every case, a set of it's legal equipment that recognizes patterns in questions that occur across fields. And you might think, well, what would this and what would A and B possibly have to do with each other? They're apples and oranges. But no, common problems emerge. And so there's a factor of recognition that helps you to deal with these very disparate subject matters. And the other thing is you train yourself to try to become a quick study, and when you get into oral argument, which is very important, you really get to ask questions that you need to know. And I'm not afraid of asking somebody to explain something to me on a very basic level, and they may think, oh, well, this judge is just miles behind me in terms of my understanding and my sophistication about the subject. But it will do them good to explain themselves in basic terms. They need to be able to leave their arcane worlds and express something to me in a very basic way that will let me understand what's going on and try to resolve the case. And maybe that's something people need to concentrate on a little bit in this age of specialization. You can come up with a very complicated problem, but sooner or later along the line in litigation, you're going to need to explain it to people that haven't lived with it their whole lives. They're all important. The briefs give me an inclination as to how I want to resolve a case. But the oral argument is really critical, and it's good to emphasize the point, because some people say, well, oral argument is just for show, that it's just the judges going through the motion, that they really have their minds made up on the basis of the briefs, and this is all just some kind of this is all ceremonial. And that couldn't be less true. I mean, there are many times when I've changed my mind a little bit or adjusted my mind after oral argument. And one of the things which your good question points out is that you get to hear the views of your colleagues as well as the litigants. So when you're at oral argument, there are a minimum of 4 or 5 different voices coming in on you, informing you, all of them. The colleague on this side, the colleague on that side, this litigant, that litigant. So it's coming in on you from very different directions, and it would be a remarkable thing to say, well, all of this had no effect. I mean, it does most decidedly have an effect. it's an odd thing because sometimes the attorney who loses gives the best oral argument, gives the best performance, and that's really different from a law school moot court thing where we award the golden ring to the students who make the best argument. Well, when you have a real live case, you know, there may be limits to what even the greatest lawyer can do with a bummer of a case. You can't just work miracles up there. You know, facts are stubborn things, and statutes are stubborn things, and so you get sometimes these lawyers who lose a case. They still contribute enormously to the opinion by informing us, and they make a great contribution to the judicial process. And I've had to resist the temptation really to write a little note and a little letter to the losing lawyer and say, you know, you lost this case, but you made a great argument, and it really helped the understanding of the bench, and we really appreciate everything you put into it, and the like. And then I thought, well, you know, that's not going to go very far because the lawyer's going to, what's the lawyer going to say? Is he going to speak to his clients and say, well, John, we lost the case, but the judge thought we did a great job and contributed to the development of the law. And then John says, you mean I got to pay a judgment of such and such amount of dollars? So I've resisted that a little bit but one day I may write that letter. One of these days I may write that letter, because my gratitude to people for their contributions to the process to helping us come up with a good result is really immense. Yeah, it's so much impacts on it. You know, I'm sitting there and I'm saying, all right now, and we sit in panels of 3 in an appellate court, and one of the things I got to do is no single judge on a circuit court can make a decision. You have to get along and rely on your colleagues, and you learn a tremendous amount from them. But you have to convince at least one other person, and preferably 2, that you're not nuts. And so I'm thinking to myself, okay, I know this colleague pretty well, and he or she emphasized this to me in conference, and I want to make sure I cover that point. And I know this will be of interest to them. So a lot of times the whole product of an appellate court, it's not an individual product. It's a collective judgment. 3 people make better judgments than 1. That's the judgment Congress made, and it's absolutely sound. So I'm thinking about the person whose vote I need when I write that opinion, and I want to respect where they're coming from. It's really different. When you write a novel, you don't need another vote. And that was one of the things that surprised me when I got on the bench, is that anything I said I need another vote for. I mean, in class, I didn't need another vote for something I was going to say. If I was going to write a newspaper article, I didn't need another vote. Editors perhaps, but I didn't need another vote. But in this job, somebody's got to say, yeah, I agree. And so you need to take them into account. And then you need to take into account certainly the Supreme Court and what its decisions are. And nobody likes to get reversed by the Supreme Court. It's like a spanking. It's not something you want to happen. So, they're my bosses. And you try to please your boss. So that's what you think about. And then another thing you think about, you think about the law as a whole. the precedent of it, the standard of review of it, what went on in the trial court, the finding of fact that the district court made, the text of a provision, the history of a provision. What are the roles of other organs of government? How does Congress play in here? How do the executive branch prerogatives play in here? What's the role of state government? What's the role of the private sector? There are a lot of other actors out there, and so you're just one part of a very intricate piece of social machinery, and you have to respect the competence and the job that other organs of government and other people are meant to do. So there's no magic bullet. I mean, this is not a mechanical exercise. There's, there really isn't there really isn't a robotic element to it. It's part art and it's part science. But having said all of that to you about all the different things I consider, at the end of the day, there are those litigants in front of you. We hear just lawyers, but behind every lawyer is a real live person. And so, when you get through all the complexity of it and all the legal doctrine and the rest, you still have to say at sundown, how does this impact those people? This is a judgment. It's going to be observed. How does this fall on somebody's life? And you've also got to think, what's the long-range public interest here? Are you doing? You want to consider that individual human being and his or her dignity, but you also have to consider the impact on the society at large and whether you're damaging a larger social fabric when you resolve a case. This is not an easy job for any of us on the bench, and at the end of the day, you probably say to yourself, well, I did the best I could. I gave it everything I had. No, I think particularly with litigants, you've got to be strategic. I mean, there's the adversary process is not I don't like to refer to it as a game. It's much too serious for that. But is there strategic behavior in the course of the litigation process? Absolutely. I mean, people they're practical people, and you want to win. The only thing I can say is that it's very tricky to do it that way, to sort of target this particular person. I mean, it's sometimes just too obvious, and it doesn't look. It doesn't come across in an attractive way when you are just so obviously playing to any one particular individual on a bench. And I'm not speaking just about the Supreme Court. I'm talking about all courts. It is much more, I think, creates a much better impression when somebody approaches the court's jurisprudence as a whole and doesn't sit there and say, well, as you said, Justice so-and-so, or as you said, Judge so-and-so. It's more effective, I think, if you do what we were talking about earlier, which is understanding that courts are collegial bodies, that they make collective decisions, and you treat the corpus, the whole corpus, not as a respectful whole, and not just try to aim your comments at one particular jurist. And I think it creates a better impression for everybody. Well, I think the purpose is in significant part an educational one, not just for the bar and the rest of the bench, but for everybody. And the Chief Justice is wonderful in communicating the aims of the judicial system in a very straightforward way and in a very humorous way. And when he talks, I think it makes people respect the judicial system all the more. And what I'm trying to do with an interview is give the subject of the interview a chance to get across the educational points about the judicial system. You know, we're the most obscure of the major branches of government in one sense. Our deliberations are behind closed doors. We're deliberating on a case, and nobody knows the course of those deliberations, or they shouldn't, until the case comes down. So there's a bit of this mystique, you know, the judges or the justices hear oral argument, and then what happens? They disappear behind this red curtain, nothing ever to emerge until the decision comes down. So you have this basic obscurity, and what is necessarily a certain lack of transparency to the way courts decide their decisions. They may add to a certain mystique, I don't know, but we need to understand that people don't know about the judicial branch because we don't have to face them in elections. We don't go out and just glad hand and, you know, socialize the way their elected representatives and others would. Okay, so given that, don't we have a major educational mission to perform to at least try to inform the public of how, in a general manner, we go about deciding cases, and at least to talk to them about the values that those of us in the judiciary hold dear, how we conceive of our mission, why it's so important to have a system of independent courts, and, you know, occasionally to have the interviewee, you know, drop a little personal tidbit or something which is of interest, because you want to humanize the process too. So it makes sense to ask, what's your favorite movie? Or what's your favorite book? Or, you know, what did you think of somebody that you clerked for? You know, we're not, you know, we're very human, which means we make mistakes, but really try to get the interview, you know, to appreciate the humanity, and the Chief Justice is wonderful at that. And I say this, he's a great representative of the federal judiciary. And when you talk to him, you realize how seriously he takes the values that the third branch represents. Yeah, I mean, I think the answer to a question like that is very circumspect, because you don't want an answer to be construed as throwing off on any particular individual or the composition of any particular court. So, you know, these judges really have to be careful about what they're saying. And particularly when you get to the level of Chief Justice Roberts. But the interesting development is that in the days of the 1950s and 60s, you had a number of justices who were former United States senators. Some of them had been former attorney generals. Some of them had been governors. Some of them had spent their lives substantially in private practice. And so the development was that overwhelmingly now, the justices have come from the courts of appeals. The reasons for it, I suspect, but so there is this trend, and it's just impossible to deny it. The reasons for it, I suspect, are that you want that judicial experience. I think that's one reason. Another reason is, to be perfectly blunt, the appointing authority, maybe the issues before the courts are so controversial that the appointing authority wants some clue or indication as to what the prospective nominees' views are. I mean, it's inescapably, the confirmation process is a political one. So the question is it a good development? And that's not an easy question to answer, because I do think that judges who've been on the Court of Appeals have brought a set of judicial skills and know-how and expertise in terms of the law, and they bring a very large and general legal background, which allows them to hit the Supreme Court running. But the other side of it is that there's a large slice. In fact, the vast majority of American life is really taking place outside the courthouse walls, and you might want people to have really kind of bloodied their nose in politics before going on the bench. I happen to think that politics, you have to put it aside when you go on the bench, but it teaches you certain things. It teaches you the values of compromise. It can teach you the importance of keeping commitments. It teaches you about people in all walks of life and what matters to them and what they're saying and what they're thinking. And so, you might want people who are a little bit beat up, and I say that in the best kind of word, by the political fray. And it's also important that courts respect the legislative process and the political process, and show restraint in the face of legislative judgments. And it might help if you'd actually been in that process and saw the way the sausage was made. Well, that's a good question, and I think just as a citizen, we all wish that there was less gridlock and more compromise, and there's a natural desire for that. So but I don't think that the fact that there is gridlock and that there's too much gridlock, which I think we would all agree on, that's no reason to give up on the legislative process. I mean, people come to me and say, "Oh, I just despair of Congress," and I can understand that. But politics by its nature is messy. It's not a lovely enterprise. It's not clean. It's it's rough and tumble stuff, And given the way this republic of ours was designed, with two houses of Congress and the states and the federal government and the executive and the courts, and you've got separation of powers and all these different centers of power, this Madisonian system is going to produce endless contention. That's the way it was designed. Would James Madison have just, if he were somehow brought back to life, would he be wringing his hands and just deploring the modern day Congress? And, you know, I'm not sure he would, because they had some pretty rough battles back then. When you think of what was going on in the election of 1800 and what Thomas Jefferson and John Adams were calling each other, with a little bit of some of this stuff is child's play. And so I don't think he was not a naive man. He was an intellectual, James Madison was, but he was right there in the middle of the fray. And he knew what was going on. So the system is going to produce a certain bit of gridlock. Was gridlock the worst sin that the framers of our Constitution could imagine? No. It was there was a greater danger to be avoided, and that was the danger of tyranny. And as between gridlock and tyranny, I don't want to oversimplify the question, but I think Madison's factional design would have preferred the argumentation and contentiousness of gridlock, because nothing was worse than losing this marvelous American experience of self-governance. Nothing would be worse than to have judges attempt to become super legislators in their own right. Nothing would be worse than to have an all-powerful executive. Nothing would be worse than to have a Congress completely unchecked. So you're going to have a certain amount of gridlock. But my gosh, how much better is that than tyranny when you get right down to it? Yeah, I think it's, I try to think to myself, well, what can we do right? What can we do, and what shouldn't we do? And I think of this Constitution of ours as a scolding parent, and it waves a finger at government. And it says, you may not do this, you may not do that. It's like a parent, this Constitution of ours, talking to a child and says, you may not infringe freedom of speech, you may not infringe the free exercise of religion, you may not conduct unreasonable searches and seizures, you may not discriminate on the basis of race, color, or creed, you may not deny someone of their right to counsel, or their right to cross-examination, or their right to subpoena witnesses on their own behalf. You may not coerce confessions. You could, on the one hand, look upon the Constitution as a constant scolding nag at government, and judges are, I think, extremely well equipped to enforce these do-nots, which lie at the very core of American liberty and at the very core of who we are. And when a branch of government begins to trample on these very fundamental rights, you're going to find the judicial ears perking up pretty quick at that. Okay, that's what we can do well, is enforce the constitutional do-nots. What we don't do particularly well is to take leave of the document itself, wander away from the law, start creating all these unenumerated rights which just have no textual grounding. When we get away from the law by creating these unenumerated rights, we're out on our own, and we don't have the very thing, the law, that gives us respect and authority in the eyes of the people. Then we just become legislators in our own right, and that's not good. And when we leave enforcing these do-nots and interpreting statutes and sticking close to the law, and we start leaving the enforcement of our enumerated rights and start trying to draw up all these tests for checking the enumerated powers of a coordinate branch of government, we're taking a big step. So you always have to, it's like you can't see too well, and you're trying, as you navigate these cases, you're trying to hold on to a railing at all times. And that railing should be your constant companion. And that railing is the law. And the law is made up of all these wonderful raw materials, the chief of which is words. I mean, the rule of law is a rule of words. And what we did when we framed that magnificent Constitution of ours is we exchanged bayonets for words. That's what we did. We said, lay down your arms. We will not have the rule of arms. We will have the rule of words. Okay, but the quid pro quo for the rule of words is that we take words seriously. And judges, most of all, have to take words seriously. And if we go fabricating stuff without a strong textual basis, we get on thinner and thinner ice. And got to understand, everybody needs to understand what they're good at and what they're bad at. We have certain things we're very good at, and we have some other things that, well, we need to stay away from. Well, we have a system where there are 1,000 answers. We can't, these questions are so difficult that you can't expect, often you can't expect any one single answer. And, take a question where people take a question such as reproductive rights, and there are going to be many different people with many different views on that. And one way to look at it is that there shouldn't be any one answer, that there ought to be a dialogue among different people with different views, that people ought to, in the political process, listen to one another's views respectfully, if that's possible, on these very flammable subjects, but that it's not wrong for the American system to supply different answers. It's not wrong for Texas to go in one direction and for Rhode Island to go in another direction. It isn't wrong to have these things in a constant state of communication and dialogue and evolution, because they involve questions that are so important to people's deep moral beliefs and to their faith and to the rest. And it's very difficult, unless the judiciary has a strong mandate in law, for the members of the legal profession, even if they happen to be on the bench, to be telling financial analysts and plumbers and school teachers and firefighters and IT specialists and everybody around the world everybody around the country, this is what you should think about this question. We can do it if we have a strong constitutional mandate, but it's hard to say my way or the highway to 300 million people when you're only 5 members of the legal profession. I wouldn't want a wonderful profession, but I wouldn't want bankers telling me what I had to do with respect to to the way I feel about some of these very volatile questions. I don't think they want lawyers telling them what they should do on this, unless we have a solid grounding in the law, and then we must move. Oh, it's not backing away. See, some people think restraint is abdication, but as a judge, you need to say, you know, it's not always what do I decide. It's may I decide. You have to ask that question, may I decide? There are questions that you need to just respect what the legislative branch comes up with. That's not abdication, that's not backing away. Now, suppose the legislative branch hasn't come up with a solution. Well, that doesn't mean we're going to charge in. I mean, what are we supposed to exercise the power of the purse and set out appropriations? Are we supposed to decide how the sequester is going to be administrated? It would be preposterous. We don't have the tools, we don't have the institutional expertise or the staff expertise or whatever, and sometimes you have to say it is best for someone else to decide. You would say to me, well, but suppose they haven't decided. Well, that all goes back to what you mean by decide, and sometimes, again, decision is going to take a lot of false starts. It's going to take, before we come to a resolution of a question, there may be 2 steps forward and 1 step back, 3 steps back, because democracy doesn't move in an even line. And sometimes we just need to let it all play out outside the courthouse walls. We need to let it play out. And I certainly understand what you're saying, and that's why I tried to say this is not a matter of absolutes. In other words, among the great constitutional do-nots is the 14th Amendment. Do not deny any citizen equal protection of the law. 15th Amendment says you must not deny someone the right to vote. And the 14th Amendment is one of the great amendments to the American Constitution, and it is one of the clearest, which is that do not discriminate on the basis of race. Whatever else you might say, that's a core principle. The decisions in Brown versus Board of Education and Loving versus Virginia and many other civil rights decisions of the Supreme Court, those were among its greatest moments, Brown and afterwards. And of course, Plessy and Dred Scott were among its most tragic moments. But this goes back to what I said. I think Brown versus Board of Education, completely justifiable. And the same thing with a case like Loving, because they're firmly within judicial enforcement of the Constitution's famous do-nots. The 14th Amendment is part of that scolding finger that says what government may not do. And so those were great days for the judiciary in Brown and many other civil rights cases when they stepped in to vindicate the right of every American citizen to be considered for whom he or she is, and not on some deeply unfortunate criterion such as race. it's fun for me because when you're working on a case, you're working on something where the canvas is 75% complete, and so you're finishing it. Also, the subject of the case has been chosen for you, and when you're writing a book, you get to choose your own subject. And as I say, you don't have to get that other vote. And so it's the difference between when you're working on a case, you're working within a drawing room and you're working inside. When you're working on a book, you get to gallop over the wide open prairie. You get to be outside. And so I like the two things because each form of writing seems to me to be a relief, a nice change of pace from the other. And, as to what people get from the books, a lot of times they're really going to disagree. They're going to say, I just don't agree with this at all. I'm going to tell him so. And I've gotten an awful lot of letters and reviews and people who just, both with books and opinions, I might add, that said, this is a major goof. And how could you be so stupid? And that kind of, they're more polite about it as a general matter, but that's what it is. So you're going to get people that just don't agree with the way the case is decided, and they don't agree with the way the thesis that you're having in your book. But ultimately what I want them to come away with is this, which is, okay, you and I may have a vehement disagreement. And that's fair, and that's what this great country is all about. But when 5 o'clock comes and it's quitting hour, I want you to know, and I hope this comes through in the book, that we really tussle with each other all day long, and maybe we're both just a little bit as exhausted. But hey, we're Americans. We're all American citizens. So what do you say? Go down and let's have a beer. Well, I'm embarrassed to admit this. I don't drink beer, but I'd like to go and have a glass of wine, and somebody else can have a beer if that's what makes them happy. And so we'll say at the end of the day, hey, look, let's not concentrate just on where we have our differences. Let's concentrate on what being Americans has brought us in common. And that's what I hope they get. The biggest satisfaction is, just I'm a patriot at heart, and I do get very sentimental about the flag and the Pledge of Allegiance and America the Beautiful. And I can't sing that song without choking up. And so the chance just to play a very small part in public service for the United States of America is all I could have asked for. That's all. I can imagine no greater gift that this country could ever give to me than a chance just to be a public servant. That's what I love about it. But at the same time, the source of that love is the source of my greatest fear, because government and civilization is a very fragile thing, and there are a number of threats out there, both armed threats, environmental threats, threats of all sorts, threats of mutual animosity, and it's going to take a good bit of vigilance and dedication to keep this great ship of ours sailing smoothly for the next few centuries. And I worry about the dangers. I worry about the dangers, and I don't think we never know what the future brings. But given the rapid change in technology and the conditions in which we live, it is impossible for me to know whether my children and grandchildren will live the same happy life that I have. And that's what I want. And that's, I think, why everybody devotes their life's effort to, is just making sure that, even if it's not in your immediate family, that what we all want, those of us in public service, is that succeeding generations of Americans be left a great and beautiful country that we've enjoyed. Well, I would say that large journeys begin with very small steps, and the best thing you can do is each and every day is just take that little case in front of you and just understand just how much depends on your giving it your best shot. And I would say, you don't need to look at what you're going to be, where you're going to be 50 years down the road, or what your whole career is going to amount to. It's just a lot of judicial work is a lot of small building blocks, and each building block is a case. And if you do your best on each and every case, I think that larger picture will take care of itself, and you'll be awfully glad you chose to be a judge, and you'll have the same satisfaction that I have.